look at the,
She's logging on,
okay,
CJ.
you see her? All right, perfect. Oh, there. Yes, she is.
I'm sorry, I was having trouble getting in.
All right, Justice Merriman has joined us, and we'll now start. Will the clerk please open the court?
The Supreme Court is now in session. The Honorable Robert J. Torres, Chief Justice, presiding.
All right, and will the clerk please call the case?
This is Supreme Court case numbers ADC10-005 and ADC12-002 in re Stephanie Flores. Appearing on behalf of the Comprehensive Lawyer Regulatory System is Regulation Counsel Alicia A.G. Limtiaco. Appearing pro se is Stephanie Flores. The panel consists of Chief Justice Robert J. Torres, Justice F. Philip Carbolito, and Justice Catherine A. Merriman. The parties have 15 minutes each to present.
Would you like to reserve any rebuttal, Ms. Limtiaco, of your 15 minutes?
That would be fine, Your Honor. Thank you.
All right, no reservation then. You may proceed.
May it please the court, and thank you, Chief Justice Torres, Justice Carbolito, and Justice Merriman. On behalf of the Investigative Committee of the Comprehensive Lawyer Regulatory System and the Office of Regulation Counsel, we submit our motion for an order finding Respondent Stephanie Flores in contempt of the court's prior orders and for an order of sanctions to include the garnishment of her wages and permanent disbarment from the practice of law in Guam. As set forth in our motion, Your Honors, the Supreme Court of Guam has issued several prior orders, to include the order of February 8th, 2011, issued in ADC 10-005, in which a judgment of discipline was issued against Respondent and an order to pay $10,417 in restitution and $6,000 in cost and fees. An order of July 19, 2012, issued in ADC 12-002, in which Respondent was ordered to pay $85,867 in restitution and $7,500 in cost and fees, and an order after hearing issued on October 26, 2017, in which we understand to be a consolidation of both cases, ADC 12-002, in which at that particular hearing, Your Honors, the court did not hold Ms. Flores in contempt at that time and gave her an opportunity by not imposing sanctions and not finding her in contempt by allowing opportunity to pay the amount of $200 every 2 weeks beginning November 1st, 2017 to the Financial Management Division of the Judiciary of Guam with notice to then prosecuting counsel of each payment. In 2022, Your Honors, the Office of Regulation Counsel requested a review and audit of the relevant financial accounts pertinent to these particular attorney disciplinary cases to be made by the Financial Management Division. We also made numerous efforts to contact and communicate with Respondent via phone calls, written correspondence, including emails and letters, and in-person meetings. As we summarized in our motion, we did send out also follow-up letters to include a letter dated December 13, 2022. We also did, in fact, set up in-person meetings with Respondent on December 22nd, 2022 and February 22, 2023 to follow up on the payments of restitution and attorney's fees and costs that the court had previously ordered as far back as 2011, 2012, and 2017. There were, in fact, meetings held on this day with Respondent where we reviewed the financial accounting and the amounts due. There was a proposal at that time made by Respondent for a payroll deduction of approximately $500 to $600 a month. And we had also introduced in person Mr. Toledo from the Financial Management Division in an effort to facilitate the payroll deduction process and to try to move this matter along and to give respondent yet another opportunity to be in compliance with the court's orders. Respondent also indicated that there was the possibility that an unrelated civil matter in which she was potentially settling with one of the restitution victims and rightful recipients of these cases may have in fact been satisfied, and we had requested documents in order to provide us an opportunity to verify that information. None of that was provided to us. And so after the meeting on February 22nd, 2023, we continued to follow up. There was a $3,000 payment made by the respondent on that day, and then a $357 payment made on March 3rd, 2024. Between April 2023 and through December 2023, again, numerous phone calls, emails sent, and no response. We did request alternative contact information from the respondent and did not receive any. We followed up with yet another letter in December 2023, and in another letter dated February 9th, 2024. That letter was not only sent via email, it was also mailed, I believe, and if not mailed, we served respondent in person at her place of employment. Again, reiterating the need for her to comply with the court's orders, the fact that we have rightful recipients and restitution victims have been requesting status of their payments who are in need of having those restitution payments made to them for various issues involving their own livelihoods. In our February 9th, 2024 letter, it was requested that she respond by February 23rd. Otherwise, the Office of Regulation Counsel was authorized by the investigative committee to pursue further legal processes, including the garnishment of wages. We did not receive a response. As we move forward, Your Honor, we can see that based on the declaration provided by Mr. Mardav Toledo, the Deputy Administrator with the Financial Management Division, and based on the audit and review conducted in these attorney disciplinary cases, as of March 15, 2024, respondent did not make payments to 141 of the 167 scheduled biweekly payments due. If the 167 scheduled biweekly payments were followed, respondent would have paid as of March 15, 2024, a total of $33,400 with an outstanding total balance owed of $77,595.86. As of March 15, 2024, respondent has made only 26 of the 167 scheduled biweekly payments due, and the Financial Management Division has collected only $5,357. Therefore, as of March 15, 2024, and given respondent's payment of $5,357, the total amount owed of the 141 scheduled biweekly payments is $28,043. The outstanding total balance owed as of March 15, 2024 is $103,578.86 for steps 1 through 5 and $105,638 $105,638.86 for steps 1 through 6. The step 6 refers to those victims and rightful recipients who then prosecuting counsel had not been able to receive contact information.
Ms. Limtiaco,
Yes.
you're seeking a writ of execution from the court as part of your motion for holding a respondent in contempt and imposing sanctions and directing that the marshal seek to satisfy the sum under the judgment or out of the court's orders, out of respondent's personal property, and if not, then out of respondent's real property. You also ask for a notice of levy and levy on wages, but it's not clear to me what amount you would be seeking on the notice of levy and the levy on wages.
Yes, Your Honor. Given that we again have the new Guam rules for lawyer disciplinary enforcement and disability proceedings, the investigative committee and the Office of Regulation Counsel discussed that we would propose this process to the court. Essentially, what we are seeking, Your Honor, is the garnishment of the wages of respondent. She is employed, and we are aware of her current salary, which is a substantial amount. We would request, Your Honor, that she be up to date at least as of what we've been able to assess of March 15, 2024. We would work with the Financial Management Division because obviously we're now in June of 2024, but we are requesting that she be made to, that she make her restitution payments so that she has complied with those monthly payments that the court previously ordered to do to the present. And that is our request.
So you indicated that she only paid roughly 15% of the payments to date, or a little over, which was, I think, what did you say, 20 out of 67? Or
26, 26,
out
yes,
of 167.
yes, and the total amount was $5,357 that has been paid.
But and so it's not clear to me from the request in the motion for the order on sanctions. Are you seeking that she pay the full amount outstanding and then the levy on wages will be prospective of the $200 previously entered in the court? Or are you asking for a new amount of levy to include current payment of $200 or the scheduled payments of $200 plus some amount for the back amounts that are owed?
Your Honor, we did discuss this matter with the Financial Management Division to gain a further understanding of that aspect of the process. The investigative committee and the Office of Regulation Counsel is seeking an order by which the respondent will be in compliance with the payments of restitutions that are due up until this point in time. So the garnishment of wages we requested was because no garnishment of wages has been instituted previously. Respondent has obviously failed to voluntarily go into the court to make payments other than those we have indicated. And in order to ensure that we have the restitution victims and the rightful recipients of these particular attorney disciplinary cases made whole, we need an order from the court. We understand that respondent, who is present here today, will indicate what her personal circumstances are. However, we are talking about Supreme Court orders that date all the way back to 2011. 2012, and then again in 2017, where the court withheld finding her in contempt and gave her an opportunity to make these payments. And it has been a challenge and a struggle to communicate with respondent and to get these payments made. And so this is a very...
Since you're seeking a writ of execution and a notice of levy and levy on wages, would it be appropriate for the court to, if we determine that sanctions are appropriate in this case, and that the respondent, Ms. Flores, should be held in contempt. Refer the matter to the collection court for having a judgment debtor examination and entering an appropriate order for levy on wages and writ of execution on properties.
Your Honor, the investigative committee and again, the Office of Regulation Counsel did briefly discuss that as a possibility. We would defer to the court in terms of that process. What we want to emphasize is respondent has been given multiple opportunities. She is clearly making, at least based on the last staffing pattern that we have been able to find, over $85,000 a year. And it is very difficult to understand the over 10 years, essentially, that only $5,357 have been paid in compliance. So we would request respectfully a process by which Ms. Flores is held accountable and that we have an order in place that will ensure that she complies with the court's orders and that the garnishment of wages will be in an amount. And she proposed this herself in the more recent 2 meetings that I indicated, of $500 to $600 a month. That was her proposal at the time versus what she has submitted to our office. And if I may, Your Honors, we received just yesterday a phone call from Ms. Flores after all this time has passed, when she has been provided multiple opportunities during the duration of these 2 cases. Just yesterday afternoon, I was informed that she called our office because she's going to work out a payment plan or a payroll deduction with the Financial Management Division. Mr. Mardav Toledo sent us an email saying she did come by at about 2:20 p.m. This is just yesterday afternoon, the afternoon before this court hearing, and that she was told to go to the Department of Administration at about 4:49 p.m. yesterday at the eve of this motion. We received an email from Ms. Flores with an attachment that appears to be a payroll deduction form that indicates that Ms. Flores will have her payroll deducted $200 a month starting June 15th, payroll period ending June 15th, 2024. And this is via the Department of Administration. We have not had any opportunity to coordinate or communicate with the Financial Management Division on this to verify, this process. But obviously, we will need to do that. We are just at a point, Your Honors, that in order to protect the interests and the welfare of the restitution victims and rightful recipients, who again have been involved in these cases even before 2011, to get them and make them whole. And yes, Your Honors. And so again, given the severity and the history and the numerous opportunities to allow her and to facilitate arrangements even on her behalf with the Financial Management Division, she has failed to comply. And this is a severe situation. Thank you, Your Honors.
Thank you, Ms. Limtiaco. Ms. Flores, in response.
Thank you, Your Honor. There's obviously not a sufficient reason for not completely paying off this amount by this time. I will let the court know, as I've let not only Ms. Limtiaco, but the prior counsel know, that almost immediately after these cases were completed, there was a garnishment by one of the claimants. And that's been ongoing since, I believe, 2011, which took 25% of all salary. And it's still in place today. And so my request back then to Mr. Bradley was if that amount could be offset against what is owed. And the response I was given at the time was, no, that's your problem, figure it out. And so at that point I felt, Okay, you've got
Which
25%.
client
It's not being,
obtained the garnishment that's identified in the court order or
I'm
former?
sorry, Your Honor, I couldn't hear that.
Which former client obtained the
Candeletta is the last
garnishment
name.
order?
Candeletta.
And the amount that was owed there was $10,000.
Correct.
All right. And so how much have they garnished to date?
Just from the government of Guam, since I've been working for the governor's office, I believe the last count was 85,000.
For a $10,000 restitution claim?
No, she claimed for additional amounts on top of that. But I had requested if part of that could be counted towards this, towards the 10,000 here.
But even the 10,000, Ms. Flores, I mean, when you look at the amounts, you were supposed to pay $200 every 2 weeks. And even if, you know, Ms. Limtiaco has set forth, I think, the number of payments that you've made has been less than 15%. And it shows that according to the financial division, the overall obligation is $110,000. So even if you take out the $10,000 that the Candeletta's supposedly garnished on, you still have $100,000 that's owed for the restitution in those cases. And then and the amounts that have been collected are nowhere even near the $200 a month or every 2 weeks that was required to be paid. I mean, there's, you know, clearly, you know, significant gaps there. And you didn't file a reply to the motion. And so it's difficult for us without filing in front of us to be able to examine, for example, the amount of wages that you might have available that's not subject to a wage garnishment order effectively, so that we can understand the situation. And so we have to take essentially has set forth by counsel what your wages are that are there and the amounts that you're required to pay in, which, you know, seemed very reasonable. And in fact, Regulation Council had stipulated to the $200 every 2 weeks. And this, you know, and when you look at the payment amounts that have been made over that period of time, they really have not been. I mean, when you look at the beginning balance and the total amounts that are due, the total amount that's still due is $105,000. And even if you take out the $10,000 from the Candelettas, and there's a big gap in terms of when was the last time you made a payment? According to this schedule, it shows March 3rd, 2023.
I'm not going to dispute that, Your Honor. If that's what it shows, that's what it is.
I mean, that's what it's showing on the schedule, and it was $157 as of March. So, you know, in a year, it doesn't show that any additional payments have been made. And even for those earlier payments, there were payments made in 2017, sporadic payments in 2018, and obviously from 2018 until 2023, there, you know, a period of almost 5 years. I mean, we understand COVID and the situation, but you know, during that period of time, almost 5 years, that's there. On the proposal that you went to the Department of Administration to get a wage garnishment order entered, or a wage assignment order, or not order, but a wage assignment done with the Department of Administration, how much was that you were putting forth?
It was, I followed the court's order, which was $200 a payday. What Ms. Limchaco was discussing was my proposal that should I be able to settle the Candeletta matter, I would then increase it to whatever I was paying to Candeletta, I would pay that entire amount to the court, which is, I believe it's almost $600 a pay period, not a month. And so I am still willing to do that, assuming that I can facilitate the settlement with the Candelettas. They've received well over $100,000 by this point. And so I think that they should be okay with settling the remainder of that matter. And I'm willing to do that because I've been living with that kind of deduction from my salary, which is a full 1/4 of my paycheck goes there.
DJ, I just want some clarification. I'm not following this. So there is a outstanding obligation to Condelesa. I'm not really sure about the pronunciation of $10,000. Yeah, I don't have the pleadings in front of me, but and you've made a payment of over $100,000 on a $10,000 obligation.
Well, the way that happened, Your Honor, was there was the claim in this case for $10,000, and that claim was related to my not moving forward to probate. And so then, because I didn't move forward to probate, the Candelettas sued me separately for that probate. And so the judgment is on the value of that property in that probate. And so it's the same matter as my contention. So the value of the property that they claimed that they lost, despite an agreement between the parties despite their agreement for me not to move it forward, later on they changed their mind and said, no, we want you to move it forward. Even though at the time she was facing criminal prosecution for the transfer of that property. And it was a situation where I had discussed with them. I said, if you move this probate forward, you will be prosecuted and have another case. She didn't want to move it forward, so I did not push the probate forward. And then when that didn't happen, then I got sued for not pushing the probate forward. That's what occurred in that case. And so that's why it is, in my view, related. So there's the $10,000 claim in this case, but the $100,000+ on the value of the condominium that she transferred to herself that needed to be probated.
So there's a judgment against you for this disputed.
Yeah, that separate judgment, which is how they achieved a writ.
All right.
Yeah, I took it to mean an independent judgment obtained. That was then they're garnishing her wages for $600 a paycheck, according to the representation that you made. And it would have been helpful for the court to get some of this information in a filing, in reply to the motion. But is it appropriate? Yeah. What is your position on the court referring this matter if we decide for a judgment debtor examination and entry of an appropriate order of garnishment? And it might, obviously be more than the $200 a month that the agreement is in place. And also looking and see whether the writ of execution and any other personal or real properties is appropriate. And
I would submit to judgment debtor exam, Your Honor. I don't object to that process. I think it's probably appropriate. And just to be clear, it's not $200 a month, it's $200 every payday. Not a month.
No, I understand that. It is.
Ms. Flores,
Yes, ma'am.
do you know what the balance roughly is on the other judgment that you're paying?
I would have to go back and double check. I would need to get that information from Ms. Cantaletta's attorney, or through the Guam legislature and the Department of Administration if they have a copy of it. I do not personally have a copy of it. That matter happened while I was, it was taken by default. I was away from Guam handling medical issues at the time. But then I didn't move to set it aside or anything like that. I let it go through.
So you have now asked the Department of Administration to set aside an additional or $200 a week to be paid over, so that you would at least prospective payments have a wage assignment for what is owed pursuant to the agreement that you had. But you still have about $105,000 outstanding in payments that, I guess that's the total judgment, but you know, I don't know, Ms. Limchak, do you have the total amount of payments that are outstanding that have not yet been paid on the 200 a month times the number of payments that have been missed? Or 200 every 2 weeks?
Based on Mr. Toledo's declaration, Your Honors, what he indicated, given the audit and the review, is that so as of March 15, 2024, and taking into account respondents' payment of $5,357, the total amount owed of the 141, that's the number of payments that should have been made to date, as of March 15th, those 141 scheduled biweekly payments is $28,043. So that would be as of March 15, 2024. That is the $28,043 plus the $5,357. That total together, which would be, as I understand, $33,400, would have been how much should have been paid as of March 15th.
So you roughly, I mean, even with the wage assignment order, wage assignment that you're voluntarily now getting the Department of Administration apparently to do for the 200 a week, you still have $28,000+ of past payments that have not yet been made in order to get you current, Ms. Flores. And what is your proposal on that?
Your Honor, if I could get 30 days on that, I'll bring it current. I will find a way to bring it current.
And what happens if in the event 30 days you're unable to do so? I mean,
Then I would assume that
we've had, you know, a significant period of time. 200 every 2 weeks seemed very reasonable, and you know, the order that the court entered based on the stipulation of counsel, and now we're talking about $28,000 that has accrued on those back payments.
Yes, I understand, Your Honor. My plan is to request a hardship withdrawal from my retirement account, which I've already been working on to bring current. I know that I'll be taxed on it, and that's fine. That's my burden, and I'm willing to bring it forward. And then there are that's just what's going to have to happen.
What is your position on that, Ms. Limtiaco?
Your Honors, again, our interest on behalf of the investigative committee and the Office of Regulation Counsels, we need to make these restitution victims and rightful recipients whole. And so
in terms of her offer to pay the back amounts that haven't been paid within 30 days and then have current the wage assignment 200 continue going forward, 200 every 2 weeks.
Yes, Your Honor. At this point, if it will facilitate the payment of the back due amount and have our restitution victims made whole, then we would not object to the 30 days. Our concern, though, Your Honors, is we have had 3 prior Supreme Court of Guam orders, and we need to ensure, number one, of course, that we have the order that makes clear what Ms. Flores has to do and must do in order to bring her balance current, and that it's made very clear that that she will be found in contempt of violating the court's orders. This will be the 4th order, the 4th opportunity, and what that's going to be. What's the sanction going to be? Because we've gone over 10 years. And it's very difficult to explain to victims who call our office why they haven't even gotten their checks. Some have said they are on medical leave. They're going off island for medical care.
Right.
So
Mr. Chief
we need
Justice,
to have an enforced process. Thank you.
Mr. Chief Justice,
Yes, Justice Merriman.
may I suggest that we continue the hearing for 45 days or so? And if the payment is made and the payroll deduction is worked out and Ms. Limtiaco is satisfied, then she could request that the hearing not occur and be canceled. If these things don't happen, then we would continue the hearing.
Is that a recommendation fine with Regulation Council?
We would defer to the court, Your Honor, and yes, that would be fine.
And Ms.
It gives
Flores?
us an opportunity.
And Ms. Flores?
Yes, Your Honor. Yes, Your Honor.
I think that's a good suggestion by Justice Merriman, that we defer a ruling in this matter for a period of 45 days to allow respondent the opportunity to pay the outstanding amounts that haven't been paid in the approximately $28,000 plus, and also provide proof that a wage assignment for $200 every 2 weeks is in effect. And we'd ask you to submit a filing with the court as soon as you get a proof of the $200 wage assignment. Get that done. My understanding is, based on the representation, that might have been done yesterday, but get that filed as quickly as you can, showing that that has been done. And then we will postpone this for 45 days to see if respondent is able to make the payment on the outstanding amounts that have not yet been paid to date, and to bring her then current with a wage assignment going forward.
Thank you, Your Honor.
And the court will enter a written order to that effect. Justice Carbolito, are you fine with that?
Yes, I fully support and agree with Justice Merriman.
All right. So the court will enter a written order to that effect as well. And if there's no further business to come before the court, we'll now stand adjourned.
Thank you, Your Honors.
Thank you. Thank you.